Okay, wonderful. We're all here.
Excellent. We are here today for video oral argument in the case of Danko v. Danko, or Danko v. Danko, I'm not sure the pronunciation. So our case number 1, CA-CV20-0094. Each side has 20 minutes. Appellant, if you wish to reserve time, you are free to do so, but you'll have to keep track of that yourself. We don't really enforce that for you. I believe this is being recorded and will be later posted to YouTube, but I'm not 100% certain of that. I can't remember if there's anything else I need to tell you. We have conferenced this matter this morning via video. We are familiar with the record, and we've also reviewed your briefs and discussed this case, so keep that in mind when you're presenting your oral arguments. Judge Cruz, do you have something to add?
Yes, if counsel can mute their microphones when they're not speaking to prevent other background noise from filtering through, and then also please keep your cameras on even when you're not arguing. Thank you.
Thank you, Judge Cruz. With that, I think we're done with the preliminaries, and we will let appellant begin.
Thank you, Your Honor. Christopher Hewitt on behalf of appellant John Danko. As Your Honors have seen, this is a pretty straightforward case dealing with fundamental rights. In this case, John Danko filed 2 petitions and a motion before the court. The motion was requesting that the court vacate void orders. The petitions requested enforcement of the provisions of the decree and for modification of spousal maintenance, child support, legal decision-making, and parenting time. In this case, a day or two before the resolution management conference, 2 motions to dismiss were filed, which attacked the motion to vacate the void order and the petition for modification. At the resolution management conference, the court entered a stay in the proceedings, said that at a later point in time, the parties will be given an opportunity to file a response. That never happened. Then a status conference was set. At the status conference, the court ambushed counsel for father and dismissed all pending petitions and motions before the court for lack of jurisdiction. In the briefs, Your Honors will see that the court clearly had jurisdiction, and this was a due process violation. The court has...
Counsel, why don't you walk me through how the court had jurisdiction, and let's do it claim by claim.
Yes, Your Honor. So for the petition to enforce, the court has continuing jurisdiction to do full and complete justice. Full and complete justice was never achieved as mother never complied with the mandates of the decree. Also, full and complete justice was never achieved as the court entered void orders. The court exceeded their statutory authority. The court divided sole and separate property, which the court doesn't have authority to do. And that was...
Isn't that been already resolved in the prior appeal?
That has not been resolved in the prior appeal. So there was a prior...
I'm sorry, and I realize it's difficult when we doing this video, so I'll try and not interrupt you. Go ahead and answer your...
That was not resolved in the prior appeal. So a prior appeal was filed. It was filed a day late. The court never heard the merits of the appeal, and it was dismissed for lack of jurisdiction procedurally because it was filed a day late.
You could have raised it in that appeal.
The void orders could have been raised in the appeal. They weren't.
So you waived them.
Void orders can be attacked at any time. That's what the case law says. The court has no choice but to vacate void orders.
And explain to me why you think it's void.
Yes, because everything in family law is governed by the statutes. The court only has authority to do what they've been given authority to do. The court has no authority to divide my client's sole and separate property. That exceeded the court's statutory authority. Also, the court, via default judgment, exceeded the relief requested in the petition, and later awarded mother 100% of my client's assets. That's a void order because the court exceeded the relief requested in the petition and awarded mother my client's sole and separate property.
But that presupposes that, in fact, these assets were separate property. You had an opportunity to litigate that. You chose not to file a response to the dissolution decree. And when the dissolution decree was entered, you chose not to timely appeal. So you're conceding by taking that action that, in fact, this was not separate property, but was in fact community property that was subject to the court's disbursement.
My client didn't concede that. He was in the hospital because he had a medical condition. He missed the trial and didn't have counsel at the time.
So did he file a motion to vacate judgment?
I believe he did.
And did he appeal that when it was denied?
He filed an appeal with respect to vacating the decree. It was for other things besides provisions of the decree being void.
And he could have raised all of these issues in that appeal, but he chose not to by not filing a time.
He could have raised all of those issues in that appeal. The fact of the matter is, case law says that void orders must be vacated. They can be attacked at any time. So you can't.
Counsel, your argument is based upon the notion that the order is void because it allocated separate property as community property. But wouldn't that mean that there's never any finality when a court decides that something is separate or community? You could just come back and challenge it at any point in the future, because according to your client, that decision is wrong. It's a void order.
Until that matter was ruled upon, until it became res judicata, as in the court.
It was ruled upon.
It was ruled upon, just not in your client's favor. He didn't appeal it, so doesn't that become a final judgment?
It doesn't.
Why?
Because there was never a hearing on the merits of sole and separate property. Also, looking at the decree, you can clearly see just looking in the.
There was a hearing.
It was a default hearing. It was entered by default. My client wasn't.
But he had the opportunity to be there, correct?
No, he was in the hospital. He had a medical condition.
He had the opportunity to appear at a hearing, had some personal circumstance that he did not bring up to the court until the judgment had been entered.
He brought it up after the fact, but aside from the sole and separate property issue, just looking at the decree, it's void on its face because it exceeded the relief requested in the petition and allocated in the decree.
Which you could have addressed in the appeal previously. I would suggest you move on to the other issues you mentioned.
Yes, Your Honor. So then going to the other issues before the court, spousal maintenance by statute, the court has exclusive continuing jurisdiction during the life of the spousal maintenance. Even opposing counsel concedes.
Well, go ahead.
Even opposing counsel concedes that the court has jurisdiction with respect to spousal maintenance. The court committed reversible error by dismissing that for lack of jurisdiction. With respect to the other issue, as far as child support, legal decision-making, and parenting time, child support, the court has exclusive continuing jurisdiction on that, especially since my client has been a resident of this state since 2006.
What effect does your client's admission in South Carolina that South Carolina has jurisdiction over the child support issue have?
It doesn't have any effect. That was made by his attorney erroneously.
Well,
but case law says that
attorneys don't act in a vacuum. Isn't the client bound by the representations of his attorney?
If the attorney commits a tort, no, they aren't bound by the actions of the attorney. Attorney committed malpractice, in my opinion, by making.
And that may be a separate action that they could have in South Carolina. But didn't your client sign a notarized document avowing to the South Carolina court that he was a resident of South Carolina?
He signed a verification that was not attached to the pleadings. Verifying.
So that's a yes. He signed it.
He signed a verification that was not attached to the pleadings. He did not read the pleadings. Aside from that,
Well, then shame on him, but that's too bad, right?
it is a shame on him, but the case law says, the Board of Regents case says that you cannot change residency unless you're in the state and you have an active state of mind that says you want to make that your permanent residency. You want to stay there. That never happened.
Based upon that verification that he signed to a pleading that said, I am a resident of South Carolina, did the South Carolina court rule that it had jurisdiction?
The South Carolina court did, via a hearing where my client wasn't present, said that they had jurisdiction.
Why aren't we bound by that finding?
Because it's
full faith and credit.
So it's not entitled to full faith and credit because it's void. My client wasn't served. He didn't have notice of the proceedings.
So everything that doesn't go your way is void and we can just ignore.
I'm just requesting that the law be adhered to.
I have a question. So
Yes,
how many pleadings were filed on behalf of your client in South Carolina regarding this issue of child support?
I believe there were maybe 2 or 3.
And did your client, so your client's position is that at every instance, those filings were not filings that he requested or that he, they were not made on his behalf?
They were made on his behalf. After the court registered the decree, without him being served with the proceedings and entered a default judgment enrolling the decree, he was then forced later to react. So he requested temporary relief from the court. He requested to be able to see his kids. That didn't have to do with the enforcement action that he filed in Arizona. It was him merely trying to see his kids because he was being hauled into court outside of his state, outside of where he resides. He resides in Arizona. He's being hauled into court from adverse rulings.
Counsel, you keep saying that, but he was representing to the South Carolina court. Not only did he live in South Carolina, but the South Carolina court could make the modifications that he later requested in Arizona. And he made those representations to the South Carolina court. He didn't say, oh, by the way, I was never served. I was all of these things that you're saying now. He was saying, South Carolina court, please grant me the relief. And then he dropped the ball, didn't get the relief he wanted in South Carolina. So then he changed his tune and filed something in Arizona.
He actually did seek to try and undo what was done in South Carolina, and that was denied. All of this was taking place while the case was actively being litigated in Arizona. Mother went to South Carolina while there were active proceedings in Arizona. The case was being actively litigated in an attempt to divest Arizona of jurisdiction.
Counsel, earlier you said hauled into South Carolina court. I just want to drill down on that a little bit.
Yes,
he filed actions in South Carolina.
He did as a reactive mechanism. When a multitude of orders were being piled up against him, whenever he went to visit South Carolina, he was actually imprisoned because Mother obtained an attorney fee award against him. So he was hauled into court there.
Does he ever represent counsel to the South Carolina court? I don't remember seeing it on the record that he is an Arizona resident in any of those efforts, either in, probably not in writing, if we follow your presentation that what was in the pleadings was done by the rogue attorney. But did he ever, out of his own mouth, say, listen, I'm an Arizona resident and this should not be litigated here, or in any way reference his residency here?
I believe so. I don't want to misspeak because I don't have that in front of me, but I believe his attorney filed stuff to correct the record in South Carolina to make it clear that he's always been a resident of Arizona. It's my understanding.
Where did he say he would visit with the children when he was trying to visit with them? Did he allege that he would visit with them in South Carolina and he had a home there?
He didn't have parenting time, so he was just trying to find out where the kids were at and attempt to see them. He doesn't have a home there. His parents have a home in South Carolina. Your Honor, I would like to reserve the remaining 6 minutes that I have left for rebuttal.
Thank you.
Thank you, Your Honor.
Give us a second, counsel, for appellee. For some reason, I'm hearing feedback.
Is that from mine?
A little bit of an echo.
All right, well, we'll go ahead and start.
All right, ready? Erica Gadberry for Applee Brooklyn Danko. I want to first start with appellant's Rule 78 argument. Do you want me to make any arguments on that? The rule is pretty clear that the court has jurisdiction to be able to rule in attorney's fees when it's a Rule 78B versus Rule 78C argument. I feel like that's pretty self-explanatory, but if you'd like me to go into it, I can. No? Okay.
It's your time. You decide how you want to use it.
Okay, perfect. And then for the Quadro, again, he had the ability to appeal this. He missed his appellate window. So I just don't think that argument really warrants any time. What this is it's just a vexatious litigant who's essentially trying to get his way in whatever state will give him his way.
Counsel, let me interrupt you for just a moment, which runs a bit counter what Judge Morse just said. It's your time, but I went earlier into Superior Court mode for just a blip and caught myself when I interrupted Mr. Hewitt, and that was regarding the issue of spousal maintenance, because I wanted to ask you whether your client concedes that the Arizona court has jurisdiction over that issue.
Absolutely, we conceded it at the trial court. We conceded it in the briefings. We would have signed a stipulation that conceded that if he wanted to do a motion to amend. We've never made the argument that Arizona lost its jurisdiction to hear spousal maintenance.
Thank
So
you.
you agree that the trial court erred?
Go ahead.
I'm sorry. So you agree that the trial court erred when it dismissed that claim on jurisdiction?
Absolutely, yeah. And looking at the brief, I mean, we straight up say it in the brief. So that's not anything that we are here arguing about. The court, Arizona, of course, has jurisdiction over the spousal maintenance issue.
Perfect.
So what is
Now
our remedy on that issue?
In that one, I mean, the court made an error. Have to go back to Arizona court to hear the spousal maintenance issue.
Great, go ahead.
So in this case, it's husband, father, I guess in this case, he is trying to get the court to give him the rulings that he wants. South Carolina is not giving him the rulings that he wants, and so he's trying to come back into Arizona. He disingenuously states that he lives in South Carolina and Arizona. We've got pleadings in Arizona as well as Carolina where he's claiming that he lives in South Carolina. Specifically in Arizona, he states trying to get a telephonic permission to appear telephonically. He that he lives in South Carolina and attendance in person for the hearing would be burdensome to follow given rental cars, hotels. It's IR 274. He avowed that to an Arizona court that he had moved. There's nothing that I've seen where in South Carolina he admits that he lives in Arizona. He has filed, and this is attached to the motion to dismiss, but he even filed for Social Security benefits in South Carolina, avowing that he lives in Carolina. So to have him come here and say, hey, I live in Arizona and the court has jurisdiction over child support, child custody, it's not true and it's incorrect. And the trial court saw through what HUD's trying to do and dismissed those. Maybe a little too vigorously with the spousal support issue, but for sure for the child support, child custody issues, the court lacks jurisdiction. The trial court allowed the children to relocate to South Carolina. Mother trying to get out of the jurisdiction. She asked for permission to relocate. Husband didn't object to it. There's no appeal on the issue of relocation, and they've been there since 2018. So pursuant to the statute, there's just no jurisdiction for Arizona to hear those issues.
Ms. Gadberry, on the
yeah.
petition to enforce, as it relates to taxes, the vehicle loan, proceeds from the sale of the marital home, does Arizona have jurisdiction over those items?
I don't think that Arizona lost jurisdiction, and if you look at our pleadings, we specifically asked for child support, those child issues to be dismissed, and acknowledged that the court could still have jurisdiction over the enforcement issues. We don't agree with what the trial court did as far as forum non-convenient, because everything, all of the, both of the parties, the children, the evidence is in South Carolina. So I don't necessarily disagree, or I don't think that it was inappropriate that the court dismissed those, but I'm not going to sit here and say that the court has zero jurisdiction to hear those issues in Arizona. Arizona is the one that made those orders, and so you can enforce them here.
So did I just hear you that you wouldn't object if we simply remanded and saying, hey, this doesn't necessarily apply to forum nonconvenience, doesn't really apply to these issues, and you need to decide the merits?
I wouldn't object to that because, again, Arizona, it's an Arizona order, so of course Arizona can hear those issues. I disagree that forum nonconvenience doesn't apply here. I think that the court was right in trying to get everything over to South Carolina. However, with the spousal maintenance issue, some of it's going to be Arizona and some of it's going to be in South Carolina. As far as attorney's fees goes, the court has discretion to award attorney's fees in this case. The court found that husband filed these pleadings in bad faith, especially with the claiming that he lives in Arizona, sometimes claiming that he lives in South Carolina. The court has that discretion. So we would argue that the court was within its discretion to award attorney's fees.
Do we have updated financial information as it relates to the parties' financial information?
I don't believe so, Your Honor.
Okay.
Candidly, this is a very simple case. I don't have anything more, so if you have any other questions, I'm happy to answer them, but it's fairly straightforward, a jurisdictional question.
I don't have any questions. Judge Cruz?
I do not. Thank you, Judge Morse.
Judge McMurdy?
Nor do I.
All right, thank you, Ms. Gadberry.
Thank you.
Mr. Hewitt, you have, I think, 6 minutes and 20 seconds left. I think you're muted right now. Okay, there.
Thank you, Your Honor.
Thank you.
Turning my attention to the attorney fee award, opposing counsel says that the court has jurisdiction. Case law says that the court is divested of jurisdiction upon the filing of the appeal. Aside from that aspect of it, the court found that it did not have jurisdiction to hear the case and that the petitions were filed in bad faith. The sole evidence in the record shows my client has zero income. He's obtaining loans to pay for his attorneys. That's in the sworn and verified pleadings. Under the Eighth Amendment, excessive fines, which is what that would be, requires the court to make an analysis of the ability to pay. The court didn't do that.
Counsel, did you raise an Eighth Amendment argument below?
I did not raise it at the hearing because this was after the fact in pleadings.
But you did file pleadings on the issue of attorney's fees. Did you object below on Eighth Amendment grounds?
No, Your Honor, I didn't raise the Eighth Amendment grounds.
Did you raise Eighth Amendment in your opening brief? I don't remember.
I did raise that he had no ability to pay, and the court should have taken that into consideration, which touches on Eighth Amendment grounds, but I did not cite to the Eighth Amendment.
Did you cite to the Eighth Amendment in your opening brief?
Yes, Your Honor. In my opening brief, it's in there. I cited to the Eighth Amendment and the Arizona Constitution.
Okay, thank you.
My opening brief. So that argument was raised at the trial court level, saying that my client had no ability to pay. Also, my client objected to the fee award as it awarded for things such as clerical secretarial work, which it can't be part of the fee award. It awarded for block billing, which the court is automatically supposed to reduce the fee award for block billing. It awarded for things like duplicative billing, which the court can't do. That gives a double recovery. So there were a lot of issues with the court's fee award. Also, it was based on the court's determination that it didn't have jurisdiction when it in fact did. The court's reasoning was that there were petitions filed in South Carolina and there was an enforcement petition filed in Arizona. Well, there was no enforcement petition filed in South Carolina. And the petitions that were filed in South Carolina were a reaction mechanism. And it stems from the April 2018 minute entry where my client was not at the hearing, but mother made representations to the court that both parties had relocated to South Carolina. Then my client's attorneys relied on that misstatement in the record and just started filing pleadings, which created a lot of issues in South Carolina and Arizona with respect to my client's residency. He's avowed in open court that he's always been a resident of Arizona. He's filed sworn and verified pleadings, and he's actually
filed the request for telephonic. Who filed the request for telephonic appearance in July of 2018?
His attorney.
His attorney in Arizona or his attorney in South Carolina?
His attorney in Arizona.
Okay.
So his attorney in Arizona lied to the court and said my client lives in South Carolina and he's going to have a rental car and airfare and all of these other things. He was just outright lying to the court when he or she filed that pleading.
I believe his attorney didn't take into consideration that residency is a term of art and loosely slung it around, relying upon the incomplete record due to the misrepresentations of mother.
Well, that doesn't answer my question, does it? My question was specifically that the attorney made representations of expenses that were going to inure if he had to appear in person. And if he was actually living in Arizona, those expenses wouldn't have occurred. So my question again is, did he outright lie to the court in representing those expenses were going to happen?
I don't think he lied with respect to the expenses because my client did visit Arizona. He never lived there, but he did visit.
I mean, South Carolina.
In South Carolina, yeah. He did visit South Carolina and attempt to see his children because he doesn't have parenting time and he had no outlet in place to see his kids. This case was currently on appeal in Arizona and he was merely trying to see his kids.
So your position is that in July 2018, although father was in South Carolina, his attorney filed a pleading with the court saying that the client lives in South Carolina. He didn't really live there. He just was visiting at the time.
Yes, Your Honor. And that's also demonstrated by his utility bills in Arizona, which were filed with the court. It shows that he's been continuously living here during the disputed years. So the fact of the matter is the court has jurisdiction in Arizona on the enforcement with respect to the enrollment of the decree in South Carolina. The court in South Carolina lacks jurisdiction to modify an order that was registered and enrolled, which is what we're seeking from the court here. This is the proper area to do it. So it has to be done in Arizona because we're requesting that the court modify certain things that the court has jurisdiction to do in Arizona that South Carolina simply doesn't have jurisdiction to do. One other thing, as far as communication, the court failed to communicate. They attempted to communicate, but they never communicated with the court in Arizona to straighten out the UCCJA issue. That's a reversible error because the statute says that the court must communicate with South Carolina. That's ARS 25-1036. That never happened. It was a surprise trial via ambush at a status conference, and there was no way that my client had a meaningful opportunity to prepare and be heard at that hearing. Thank you.
Hadn't the court told the parties prior to that hearing, though, that it was going to try and contact? So it's not like the issue of jurisdiction wasn't, the parties weren't aware that the court was considering. this. The court had said, I'm gonna contact the court, and then came back at the next hearing and said I was unsuccessful.
The parties were aware of the jurisdiction issue,
All
not
right,
the.
and I would
non-competence
caution
issue.
you in future arguments not to say ambush, because ambush sounds like the trial court is doing something nefarious, and the trial court let parties know what was going on.
So it was set for a status conference. A status conference means we're going to discuss proceedings of the case. Now we're going to have an evidentiary hearing when the parties don't know what the issues are. So in my terminology, I'm saying trial by ambush because there was no way to properly prepare for an evidentiary hearing that was set for a status conference when the court was raising all sorts of issues that there was no way to be able to prepare to properly present evidence and testimony with respect to those issues.
All right, thank you for your time, both parties. Thank you for your arguments and your presentations. We will take this matter under advisement and issue a written decision.
Thank you very much for your time, Your Honors.